Okay, we got people still rolling in, but I just wanted to go ahead and just start the webinar since we're about 3 minutes past 12. I wanted to thank you all for being here today. Happy New Year. This is our first webinar of 2025, which sounds crazy to say. Another year already behind us and another one started. So thank you for being here for our first one of the year with Cole. So this obviously is to learn about what you need to know when inheriting an IRA. So Cole is going to go over all of the information you need to have tucked in your belt when this happens. And also feel free to drop a message in the chat or raise your hand if you have a question. He will probably answer a majority of questions that pop up. But if he doesn't address anything that you can think of or you're maybe wondering about, go ahead and just ask us directly and we can answer those at the end of the webinar. And as a reminder, as you probably already know, we do record these webinars and they do get posted on our website for you to look at or share with friends whenever you feel like. So Cole, take it away.
Thank you, Jasmine, for that introduction. Yeah, just like Jasmine said, it's fun to be here at the start of the new year, starting off the year with an exciting webinar here. So this is what you need to know when inheriting an IRA. The reason why we thought that we would start with this one is because the rules have been sort of changing the last couple of years. And now that they've kind of finalized, we wanted to just start off the year with something that's sort of been muddied around the last couple of years. So this is what you need to know when inheriting an IRA. It's not as general as some of the other ones that we've done in the past. It is sort of specific. So I'll try to cover as many specific circumstances as we can without getting too specific. We still want to keep it sort of a broad overview and just sort of cover the basics behind this. Let's get started. So what we'll be talking about today, I always am a big believer of starting from the ground up. So before we talk about inheriting an IRA, I want to cover sort of the IRA basics, a quick overview of everything you need to know about an IRA before we talk about inheriting one. Then when we do talk about inheriting an IRA, I'll discuss the different types of beneficiaries because the beneficiary determination does impact the rules that you are required to follow when you inherit an IRA. And then we'll talk about some specific distribution strategies and how those could apply to you depending on which type of beneficiary you are. I also have some common questions at the very end of the presentation that will go along with as well. But again, as Jasmine said, if you have any specific questions, feel free to type them in the chat or let us know afterwards. My contact information will be there at the end of the slides if you want to message me directly as well after the webinar. So IRA basics, again, before we get into inheriting an IRA, I always like to build up. The two main types of IRAs are a traditional and a Roth. If you've been on a webinar with me before, you've probably heard me talk about the distinction between these two, but I feel like it never hurts to go over again. Traditional IRA, the money in a traditional IRA is pre-tax money. So contributions to a traditional IRA have not been taxed yet. It is pre-tax money that gets put into this account, and then the distributions are taxed. Compare that with a Roth IRA. Contributions to a Roth IRA are made after tax. Post-tax money, the money's already been taxed when it goes into the account. With a traditional IRA, the distributions come out as ordinary income. That makes sense because you put the money in pre-tax and then it gets taxed on the way out. Sort of the opposite with the Roth. Money gets taxed when it goes in, comes out tax-free. Both traditional and Roth IRAs have distribution restrictions, so you really can't access the money before age 59 and a half. If you do access the money before age 59 and a half, there is a 10% penalty. When I refer to traditional IRAs throughout this presentation, I'm just going to call them IRAs. So if I'm talking about an IRA, it's a traditional IRA. It's pre-tax money, money that is in the IRA that has not been taxed yet. If I need to talk about a Roth IRA, I'll say Roth IRA, but otherwise it'll be a traditional IRA. The last important distinction between an IRA and a Roth IRA is that traditional IRAs have required minimum distributions or RMDs. And those are pretty important because that is a big distinction between the two because it impacts these inherited IRAs, or when you have an inherited IRA, you'll have to deal with these RMDs as well. So let's sort of talk about how RMDs work and what they are. required minimum distributions. Once you reach RMD age, you're required to distribute a portion of your account. So let's sort of break this sentence down into two parts here. Once you reach RMD age, well, what is RMD age? It used to be age 72, but after the passage of Secure Act 2.0, they realized that people were living longer lives, and they decided that RMD age needed to be pushed out a little bit. So they decided to push it out to age 73, and then ultimately decided to push it out to age 75. So RMD age is kind of, it's not set in stone. It's not just a set 72. It's not just a set 75. It sort of depends on when you were born. If you were born in 1950 or earlier, your RMD age is age 72. If you were born in the 50s, so 1951 to 59, you're sort of in transition year when they were trying to extend it out a bit more. So your RMD age is age 73. So once again, if you were born between 1951 and 1959, your RMD age is 73. And if you were born in 1960 or later, your RMD age is 75. So when I refer to RMD age, I'm just going to say RMD age because it could be 72, could be 73, could be 75. Who knows? They may push it out even further a few years down the line. So I'll just refer to RMD age as RMD age rather than a specific age. So once you reach RMD age, you are required to take a portion of your account out. How is that portion decided? Well, it is calculated based off of your life expectancy and your account value. So life expectancy, if you are age 80, you have your life expectancy for maybe another 10, 20 years, and they may say, well, based on your age, we want you to take a specific portion out of your account value. So say that's 5%. So if you're age 80, you have to take out 5% of your account value. And if your account value at the end of the year is $1 million, 5% of $1 million is $50,000. So that's what your RMD would be for this year. Now, you may be wondering to yourself, why do I need to take required minimum distribution? This is my money. Why do I have to take it out? Can't I just let it grow? And if I don't need it, then I won't take it. That would be nice. But ultimately, the IRS wants their money. This is money in an IRA that has not been taxed yet. So the IRS has not collected any taxes on these funds, and they want to collect money on it. So they decide to implement these RMDs at a certain age. Also, IRAs are retirement accounts. They're not wealth transfer accounts. And that's sort of the logic behind the IRS, is they're thinking, hey, this is money that you have set aside for your retirement. We gave you these tax breaks so that you could have a good retirement. We want this money spent on your retirement. We don't want it passed we don't want the wealth transferred on additional generations to your heirs and your beneficiaries. That's not what this type of account was set up for. So if you kind of get behind that logic, that's why there are these RMDs, because these are retirement accounts. The IRS wants you spending this on your retirement. These aren't wealth transfer vehicles for your heirs and your beneficiaries. Now, it is also important to remember that your RMDs are taxed as ordinary income. Remember, the money hasn't been taxed yet. IRS wants to collect their taxes. So whatever your RMD is in that previous example, $50,000, that's just going to be added right on to your taxable income for the year. So you will be taxed on that as ordinary income. Now, it's important that we talk about RMDs and sort of set the stage for this, because when you inherit an IRA, you are also required to take an RMD. So that's an important thing to distinguish as well. Sort of something that we'll talk about later on in this presentation is that when you inherit an IRA, you are required to take required minimum distributions as well. And the rules for what that RMD amount is depends on the type of beneficiary that you are. So the last thing on IRA basics are the different types of beneficiaries. So let's talk about beneficiary designations and how one gets named a beneficiary and how one inherits an IRA. So IRAs generally pass via a beneficiary designation. For those of you who have done any estate planning with us or on your own, you've probably heard us talk about trust and wills and putting accounts into the name of the trust so that they can pass on to your beneficiaries. An IRA sort of sits outside of that for estate planning purposes. On your IRA account, you have listed beneficiaries. So your IRA will go directly to those beneficiaries. You don't need to put it into a trust. In fact, you can't put it into a trust to then pass it on to your beneficiaries. It sort of sits outside of your normal estate plan, which isn't necessarily a bad thing. It's just different because it also avoids IRAs also avoid probate, which is the whole reason why we put assets in the name of a trust. So it's just important to realize that your IRA sits outside of your trust and your other estate planning documents. Also, a small nuance is that inherited IRAs, so when you inherit an IRA, they are held as a separate account than a personal IRA. So say you have your own personal IRA account, you've contributed to it, and you inherit an IRA from someone. That money doesn't get added to your existing IRA, it gets opened up as a separate account. It's called an inherited IRA. So you can have an IRA and you can have an inherited IRA. In fact, you can have as many inherited IRAs as you need. So if you inherit an IRA from your mom, that's your mom's inherited IRA. If you inherit an IRA from your dad, that's an inherited IRA for your dad. So each inherited IRA is a separate account. So now that we've sort of covered the basics on IRAs, let's talk about these specifics on inherited IRAs. So let's get into what to do when inheriting IRA and what those RMD requirements are. Your RMD rules are determined by which type of beneficiary you are. As we'll get into here, there's a couple different types of beneficiaries, and your RMD rules are determined by which type of beneficiary you are. There are three main things to consider when you answer the question, what type of beneficiary I am. The first one is actually the date of death of the account owner. So did the account owner die before 2020? So this is the original account owner. If they passed before 2020, then there's not much that you need to listen to this presentation for because the rules are kind of grandfathered in for that. Anyone who passes away now or who did after 2020 has to deal with these sort of new rules of why we're having this webinar. So that's the first thing to consider is when was the date of death? If it was after 2020, then there's probably some additional steps that we need to determine of which type of beneficiary you are. The second thing to consider is your relationship to the decedent. Were you the surviving spouse? Were you a child? It matters whether you were a minor child or if you're an adult child. Were you another person? Were you a friend, a sibling, a neighbor, a coworker? And if you were another person, how close in age were you to the account owner or the decedent? Because that also matters in this new post-Secure 2.0 era. The last thing to consider is RMD age. So was the account owner RMD age? I just talked about how how there isn't just one set number, but if they passed away before age 72, you know that they definitely were not RMD age. And if they passed away after age 75, then they definitely were RMD age. If they passed away and they were somewhere in the middle of that, well, you may just want to confirm what their RMD age was and if they were that age. So ultimately, when the account owner passed away, if they were RMD age and what your relationship to them was, that will ultimately determine your distribution options. And the two different distribution options are referred to as the stretch and the 10-year rule. So let's talk about that. So the stretch distributions are based off of your life expectancy. So this is very similar to RMDs from a personal IRA. It's based off your life expectancy and account value. If you inherit an IRA at age 40 and your life expectancy is 40, 50, 60 years, then you can take a little bit every year for the next 60 years or whatever your life expectancy is deemed to be. And that's actually determined on an actuarial table. The RMD amount is sort of calculated for you if you use the stretch. Stretch in summary is just a little bit every year over your life expectancy. The 10-year rule is a little bit different. It's a little bit more accelerated. This came into effect after Secure 2.0 was passed. It basically says that the account must have a zero balance after 10 years. Now you may be saying to yourself, well, that seems a bit faster, a bit more accelerated, if anything, maybe even a bit worse. And that is the fact of the matter. So yes, instead of taking a little bit over the course of your life expectancy, you need to take it all out after 10 years. And again, something to remember of why the IRS decided to pass these laws to sort of accelerate your RMDs to get these accounts to have a zero balance sooner is that, again, these are retirement accounts, not wealth transfer accounts. So not only did they implement the RMDs to have you drain the account, but they now want it drained a little bit faster with the 10-year rule. So again, the stretch was for pre-Secure Act, so anyone who passed away before 2020, their beneficiaries will have the more favorable stretch option. And anyone who passed away after Secure 2.0 was passed, so after 2020, they'll have to deal with the 10-year rule. Unless, and yes, there are a lot of exceptions and caveats, unless you are the surviving spouse. That's one thing. Surviving spouses can sort of do their own thing called a spousal rollover that I'll talk about in a bit. So they won't have to deal with the 10-year rule. And of course, if you're a minor child, you won't have to deal with the 10-year rule immediately. Oh, and if you're disabled or chronically ill, or if you were less than 10 years younger than the decedent. So yeah, that's sort of quite a few exceptions, and we'll talk about that right now. So what Secure Act essentially did is it created two different classes of beneficiaries. You have the rule, which is most people, and then there are the exceptions to those rules, which are honestly quite another big chunk of people. So what is the difference between these two? And most importantly, what is a most non-spouse beneficiary? I asked myself the same question too when I first learned about this, because I'm like, most, that doesn't really, that's not very definitive. It's not an all or nothing thing. What is most non-spouse beneficiaries? Well, most non-spouse beneficiaries is basically if you are not an exception to the rule, then you fall subject to the rule. And that rule, of course, is the 10-year rule. So exceptions to the rule, surviving spouses. So if your husband, wife, or partner passed away and you are the surviving spouse and you inherit that IRA, you won't have to deal with the 10-year rule. If you are a minor child, you won't have to deal with the 10-year rule, at least not immediately. Once you become an adult, you'll have to deal with it. If you're disabled or chronically ill, and if you are a person less than 10 years younger than the beneficiary or than the account owner. So that includes siblings, friends, neighbors, basically anyone. Although I would assume if you were named the beneficiary of an IRA account, I would hope that you're close enough to that person to call them a friend at the minimum. But yeah, so all these other people, they would have the benefit of doing the stretch or at least not doing the 10-year rule. So who does that leave? We talked about quite a few people. Who does that leave then as most non-spouse beneficiaries? The biggest class of people are adult children. So if you're inheriting mom or dad's IRA, the 10-year rule in the Post-Secure Act mostly will apply to you. You are the biggest class of beneficiaries that sort of had this change dealt with you. And again, going back, it's the reason why the IRS wanted to have the 10-year rule implemented is because they didn't really want to have these IRAs deemed as a wealth transfer tool. So all these people over here, a surviving spouse or a person less than 10 years younger than the beneficiary, they're sort of in the same generation. And it's when you pass it on to an adult child that sort of goes on to the next generation. That's what the IRS is trying to, I don't want to say put a stop to, but they sort of want to change the rules for them. So hopefully that was pretty clear, because let's throw another curveball in there. If the person who passed away, if the account owner was RMD age, then they would have to do sort of the stretch and the 10-year rule. They sort of get something added onto that. So perk of the 10-year rule is that you could take money out of the account over 10 years. Now, it doesn't matter if you do it all in the first year or all in the last year or spread it out in the middle. But if they were RMD age, then you sort of have to take a minimum amount and the account has to be zero balance after 10 years. So sort of just an added caveat onto that. This is kind of the overview of it. We'll dive into more specific situations after this. But so yeah, you can think of adult children as mostly in this category here as having to deal with the 10-year rule. And then the exceptions to the rule are over here. Actually, surviving spouses can do something else other than taking the stretch too, something even more favorable. And that is called a spousal rollover. So now we're kind of getting into specific classes of people. We'll talk about the surviving spouses first. So yeah, first thing that we'll talk about here is strategies for surviving spouses. And then we'll sort of dive into other classes of people. And hopefully you find yourself in one of those classes. And, you know, if this were to happen to you, then you kind of have an idea of what your next steps are. So first off, strategies for surviving spouses. You can actually elect to do a spousal rollover. So you would do a rollover of the deceased spouse's IRA into your own IRA. So what do I mean by that? Remember when remember earlier I talked about how an inherited IRA is separate from a personal IRA. If you are the surviving spouse, you can actually roll over the inherited IRA into your existing personal IRA. So this allows you to treat the funds as your own. It allows for simplicity and consolidation because instead of having two accounts with different rules, you can just have one account with one rule. Now, caveat to this is that there may be some additional planning that's required if the surviving spouse is under age 59 and a half. Now, the reason for that is if you have your personal IRA and you're under age 59 and a half, you are still subject to the early distribution penalty. So remember, if you have a personal IRA, you can't take any distributions before age 59 and a half without any penalties. Whereas an inherited IRA, there's no penalties, but there are RMDs. So if we were to look at these two different accounts, if you were to fall into the specific situation of being a surviving spouse under the age of 59 and a half, what we may advocate doing for you is opening up a personal IRA for you. So this is the surviving spouse's IRA. There's no RMDs that you need to take from the account, but there would be a 10% penalty if you took money out of the account and you're under age 59 and a half. The second account that we would open for you would be the deceased spouse's inherited IRA. Now, you would have to take RMDs from that account, but there is no 10% penalty. You may be wondering, all right, well, why do I want the two different accounts? Well, this account would be the money that you would draw from before age 59 and a half, and this account would be the money that you can draw from after age 59 and a half. If you just had this account here, then you wouldn't be able to draw any money if you needed it before age 59 and a half without that 10% penalty. So again, if you're a surviving spouse under the age of 59 and a half, there's probably some additional planning and a deeper conversation that will need to be had. But this is sort of a rough outline of what the picture would look like. So now let's look at an example of the stretch actually in action, because if you're a surviving spouse, you're likely not doing the stretch, you're going to do the spousal rollover. However, if you were, say, a friend or sibling who is in close age with the beneficiary or with the account owner, then you would do the stretch RMD. So what do I mean when I say planning for close in age friends and siblings? This is for persons who are less than 10 years younger than the decedent. They don't have to do the 10-year rule. They would qualify for the stretch. Now, you may be wondering, what does that mean, less than 10 years younger than the decedent? I think the best way to go about explaining this is just to look at a couple examples. So let's say that you are a friend who is 2 years older than the decedent. So the person who passed away, they named you as the beneficiary, and you are 2 years older than your friend who's 10 years older than them. Can you qualify for the stretch? Yes. Yes, you can. So you don't have to do the 10-year rule because you are 2 years older than them, and that is less than 10 years younger. So you can be however many years older. The rule is just trying to qualify people who are less in age, less than 10 years younger in age. So what about a sibling who's 5 years younger in age? Well, they would also qualify for the stretch because they are less than 10 years younger. So, all right, so you can be older and you can be less than 10 years younger. What about a sibling who is 12 years younger than the decedent? Well, in that case, you are more than 10 years younger than the decedent. You would not qualify for the stretch. You would have to adhere to the 10-year rule. What about a friend who is 10 years and 1 day younger than the decedent? Well, you would also be subject to the 10-year rule because you are more than 10 years younger than the decedent. So again, the more favorable strategy is for the stretch. So if you're less than 10 years younger, you have the more favorable stretch. But if you are more than 10 years younger than the decedent, then you would have to do the 10-year rule. And it doesn't matter whether you're a friend, a sibling, you're just not a child and you're not the spouse, just sort of any other person. And what about if you're a spouse who's 20 years younger? Well, I kind of gave the tip away to this one earlier, but it's a trick question. Spouses, they would do the spousal rollover. They wouldn't necessarily have to deal with the stretch. It doesn't matter if that they're 20 years younger. All right. Now let's talk about planning for minor children. So this is another category of people. They necessarily wouldn't have the stretch or the 10-year rule immediately. they would sort of be an exception to the rule. So I'll talk about this real quick because I'm sure there's not too many minor children listening in on this right now. But if you happen to have siblings who are younger, then you can share this information with them. This is only for children of the deceased owner, not grandchildren. So only if you have a child, not a grandchild, you can't skip down 2 generations. And you're still subject to the 10-year rule after you reach the age of majority. So let's say that you are age 16 when you inherit an IRA. You don't have to take any RMDs from it, but once you achieve the age of majority, which in California is age 18, now you're subject to the 10-year rule. So you're sort of given a pass until you reach adult age, and then you have to deal with the 10-year rule. So let's talk about the 10-year rule in action. This, again, will likely deal with adult children. So this is the biggest class of people who will have to deal with the 10-year rule. And just, again, a summary, you're not eligible for the stretch, and the account must have a 0 balance after 10 years. So again, the adult children, probably the largest group and most impacted by this 10-year rule change. Now, even though it is less favorable than the stretch, your RMDs can still be planned around your income and your income-based needs. So let's just talk about a couple examples of that. So you could take a tenth of the account balance every year for 10 years. You could take it all at the beginning. You could wait and take it all at the end. It doesn't matter as long as there is 0 balance at the end of those 10 years. Now, planning around this, let's say that you inherit an IRA at age 60 and you're planning on retiring at age 65. Well, something that you might consider doing is not taking any RMDs for those first 5 years while you're still working. And then once you retire, you start drawing down from your inherited IRA for those remaining 5 years and sort of live off that income before dipping into your own personal retirement. Let's say that you have a kid who is about to be in college. So say that they're 16 years old. You can take no RMDs for those first 2 years. And then once they go to college, you can take a fourth every year for the next 4 years to pay for their college. And then you wouldn't have to worry about any RMDs after that. So there are a few ways to manipulate, when to take the RMDs if you fall under the 10-year rule. The most important thing is that the account balance must be 0 after 10 years and sort of just navigating the tax consequences of those RMDs every year during those 10 years. So a couple basic questions, specifically relating to the 10-year rule, because this is the new rule. When do my 10 years start? Do they start immediately? Is it at the end of the year? When does it start? Well, it starts the year after date of death. All right, so let's say someone passed away in 2025 this year. The 10 years would start next year in 2026. So then the account must have a 0 balance at the end of 2036. All right, so if you passed away in 2025, your beneficiaries would have to 0 out the account at the end of 2036 if they fall under the 10-year rule. Another common question, is there a penalty on my RMD if I'm under age 59 and a half? So going back to that previous slide where I kind of touched on this a little bit. Yeah, spousal rollovers. The answer to the question is no, there is no penalty. When you're taking RMDs from an inherited IRA, there is no 10% penalty. The 10% penalty only really becomes a planning factor if you are a surviving spouse under the age of 59 and a half. So that's the only situation in which you'd have to sort of plan around the 10% penalty. But the answer to this question, is there a penalty on my RMD if I'm under age 59 and a half? No, there's no penalty for you taking an inherited IRA RMD. What happens if I inherit an inherited IRA? So this is another valid question. Let's say my mom passes away and I inherit the IRA. And then I pass away and I name my sister as the beneficiary. Does the 10-year, what is that? What happens if you inherit an inherited IRA? Well, you're still subject to the 10-year rule. So it doesn't matter if I were to name my spouse or a person who's less than 10 years younger than me. There's no exceptions for inheriting an inherited IRA. Once it's an inherited IRA and it gets passed on, 10-year rule. So does the 10-year period ever reset? So again, going back to that situation, if my mom were to pass away and name me as the beneficiary, I would be subject to the 10-year rule. And then let's say 3 years later, I pass away and I name my spouse as the beneficiary. Does the 10-year period reset for them? Because we know that they already have to do the 10-year rules. The answer to that is no. There's only ever one 10-year period. So in that situation, if my mom were to pass away, I inherit the IRA. I'm subject to the 10-year rule. 3 years later, I pass away. I name my spouse as the beneficiary. She has 7 years to zero out the account. It doesn't matter that she's my spouse. She can't do the spousal rollover. That only would have been true if it were my original IRA. Since it was an inherited IRA, she still has to pick up my 10-year rule. Last question, do inherited Roth IRAs have RMDs? So we talked about Roth IRAs earlier in the webinar. We talked about them not having RMDs. But what about an inherited Roth IRA, different than a personal IRA? Do you think they would have RMDs? And the answer to that is yes, they do. You may be wondering why. Why? I thought the whole point of RMDs were so that the IRS could get, their taxes, and money in a Roth IRA has already been taxed. So what do they care if the account still has balance? And that kind of goes back to, again, the idea that these are retirement accounts meant to be used for a person's retirement, not to pass wealth on from generation to generation. So even though there's no real tax implications of an inherited Roth IRA, there are still RMDs that they'd be subject to. All right. So talked about some heavy stuff here. We went a little information deep, hopefully not too deep, and hopefully it was still broad enough to kind of give people an understanding of where they would fall if they were to inherit an IRA and what the rules would be for each specific type of beneficiary. If you have any questions, feel free to type them in the chat, or you can also email me directly if you want to talk about your specific situation. So yeah, we know that inheriting IRAs are not, dealing with the money is not the first thing on your mind in these situations. So we would at least like to be here to make that part of the transition a bit easier for you. So thank you for attending. Feel free to email us if you have any questions. Jasmine?
Absolutely. Yeah. Thank you guys for attending. This will be posted in the next day or so on our website for you to share. And for those of you that missed it, please take a look. I know there's a couple people that didn't make it today on the live. Our next webinar is our quarterly State of the Markets for Q1, which is next Tuesday at 12 with a guest speaker from Vanguard. So please join us on that one as well. And we hope you guys have a great rest of your week. Bye.